वेलकम टू रोहिला स्टेनो क्लासेस। आपका डिक्टेशन शुरू होगा 3 सेकंड बाद। स्टार्ट। वन मोर कंसिडरेशन persuades this court to decline relief. Stop. It is that out of the 579 who participates, some were successful and some were not. Stop. Yet all of them did participate and accepted the conditions as it were. Stop. Permitting the petitioner oblique appellant or any other candidate thereafter to take a retest by directing the state to hold a fresh PET would itself be an unfair procedure, as it would not only allow a few candidates who approach the court to have a second shot or attempt or a second innings as it were, but also create an unfair advantage in as much as the conditions would be entirely different and perhaps favorable to the candidate. Stop. This would result in two yardsticks being injected into within bracket 1, whereby all others except participate and are assessed under poor conditions, and the second whereby those who approach the court are given a second chance, resulting in their competing in favorable conditions bracket close in the same selection process, which is inherently untenable and contrary to Article 14 and cannot be permitted. Stop para. Even in the retest within bracket, which was conducted with sufficient notice in terms of the orders of the single judge bracket close, only a few within bracket and not all bracket close candidates managed to clear the PET. Stop. Upholding the grant of a second opportunity of PET carried out in most favorable circumstances to only a few, therefore, in the opinion of the court, was not justified. Stop. Granting relief also on the ground that there were vacancies which could be filed with the writ petitioners or other candidates, in the opinion of the court, would mean that the executive government's choice of selecting from other candidates who have since become eligible is completely curtailed. The pool from which selection can be resorted to might and would be wider. However, the impugned order restricts it to the petitioners. Stop para. This court is of the opinion that the same reasoning would apply with greater force and rigor in this case as well. Stop. Out of the 151 candidates who in fact participated in the PET, nearly 55%, that is 82, qualified. Stop. Therefore, it could not be said that the facts showed manifest unfairness or arbitrariness in the case of the petitioners. Stop. After all, they, like others within bracket, both successful and unsuccessful candidates bracket close participated. They could not qualify. Stop. But a sizable number of the participants qualified. Stop. Most of those who did not qualify did not approach the court. Stop. More number of candidates qualified and passed the PET than those who did not. Stop. If one keeps all these facts in mind, the directions issued in the impugned judgment cannot be sustained. Stop. Para. For the foregoing reasons, the present appeal has to be succeed. It is allowed. Stop. All pending applications are disposed of. Stop. दोस्तों, यदि डिक्टेशन अच्छा लगा हो तो वीडियो को लाइक करें, शेयर करें और चैनल को सब्सक्राइब करके बेल आइकन अवश्य दबा दें ताकि लेटेस्ट वीडियो का नोटिफिकेशन आप तक तुरंत पहुंच सके।